I want to introduce our two next panelists. So on my left is Morgan Jones. He is an associate at McCarter in English as part of the VC technology and emerging companies practice. He is part of the privacy team and helps companies with GDPR compliance and privacy compliance. And then at his right is Seth Ludwig. Seth is part of Interpublic Group, which is one of the largest advertising companies in the world. So if you think about it, they're kind of the gateway for all of the large enterprises and Fortune 500 companies on how they spend their advertising and make decisions. So he has to help organize those thought processes and think about privacy. And previously he was at JP Morgan, so also has the financial institutions side. So I will pass it off to Morgan.
Good afternoon, everybody. Is it noon yet? I don't know. It's close enough. It's lunchtime. Everyone's eating. So hope everyone's enjoying their day so far, and please enjoy your lunch. But if you have questions, just throw a hand up. We're not going to have to wait till the end. Sometimes you lose things as the day goes on, so don't be shy. We're here to answer questions and hopefully educate without putting you to sleep. So with that, we'll kick it off. As if you needed any more. So we're going to this is a brief overview of what we're doing today in terms of GDPR. We're going to just go through some of the major aspects of it, and we'll try to pepper in as many real-world examples and hints as we possibly can. So without further ado, let's kick things off.
Sure, so thank you, and thank you everyone for joining us. As mentioned, Seth Ludwig, IPG. Obviously, these are, if I express any opinions, my views, not the views of IPG. So, just going to start us off with data processing principles. So, first one, lawfulness, fairness, and transparency. You can go to the next slide. That's pretty much as it reads, processing personal information in a lawful and fair way. Essentially, this is, providing your notice, a GDPR applicable notice, and making sure the consumer is aware of how you're processing, collecting, and using the information. And really, that really gets to the heart of GDPR, which is largely around fairness, collection, use, all those good stuff. As compared to CCPA, which we'll obviously get to in a little bit. And then purpose limitation, collecting data for a legitimate purpose. And if you change that purpose, or you have to get another, whether it's consent, legitimate basis, you have to get another legal basis for collecting that information if you change the manner in which you use that personal information.
Yeah, so even if it's the same piece of data, if you decide to start processing it for a different purpose, you have to go back and get a new basis to process that. Whether it's consent, whether it's a legitimate purpose, legitimate business interest, or whether it's to fulfill a contract. So,
you could say on that page we still have two more. Data minimization, which is always a fun one because companies, obviously love to collect as much personal information as possible, but that's not, from a privacy and GDPR perspective, not always the best thing. You only want to collect as little information, personal information, as you need to undergo that processing. So, for instance, if you're collecting personal data for an app, you just want to collect the name, address, whatever, all the information that you need to run the app and make sure it runs effectively. And
probably not social security number.
Exactly right. Then accuracy. This is an interesting one because GDPR makes you liable if you hold inaccurate personal information. So this comes into play. Well, I believe we'll talk about it in a little bit within subject access requests. So if an individual requests their personal information, they get that information back and it's wrong, you could potentially be liable. Storage limitation, just deleting the personal information kind of goes to that minimization purpose as well, when you no longer need that data. Integrity and confidentiality, I think we'll get to this in a little bit, but it's really at its heart, it's just having a robust information security program, making sure you're protecting that personal information. And then the new one is accountability, as compared to the old directive, which was the precursor to GDPR, which is demonstrating compliance, that you're in compliance with GDPR. So having your policies in place, contracts, demonstrating that you appointed an individual, such as a data protection officer, if you need if you're required to, and really just making sure you're buttoned up and documenting your compliance program.
All right, great. So there's only a few different players in the GDPR realm. You can either be a data controller, a data processor, or a data subject. So who are you in this respect, and does the GDPR apply to you? Controllers are the individuals or entities that determine the means and purposes of processing. And that goes back to what Seth was saying a few minutes ago about having a different purpose of processing. By and large, many law firms and professional institutions are considered data controllers. There's a lot of white papers out there by the Article 29 Working Party, now the European Data Protection Board. I never get the acronym right, so I always have to pronounce it. Trying to provide guidance and shine some light on who is going to be a processor and who's going to be a controller. I actually learned the hard way that shipping companies, you would think, would be a controller in that they collect information like an address to ship information to, but they're actually considered a nexus. They're nothing. They're a unique entity unto themselves, according to the Article 29 Working Party. And then you have the processors, who are basically doing the bidding of the controllers at their direction and in written instruction. We'll get into those a little bit later. Now, both of these entities can be held liable, and actions can be brought against both of them. But primarily that will rest with the controller, but that's for later on as well. Then the data subject is the lucky individual whose personal information we are dealing with at the moment. They have certain rights and privileges under the GDPR, which we'll get into shortly. And then the all-important last definition under the GDPR is, what is processing? Processing is virtually everything under the sun, including storing, including transmitting, including actually using the data. So if you have data, chances are you're processing it. Okay, so as Seth alluded to before, in order to process data, you need a purpose, and you also need a lawful basis in order to process the data. Now that all comes in one nice little section in the GDPR, and the main ways that you process data, the main lawful bases are consent, performance of a contract, and legal obligation. These are by far the most popular and most common. Consent is very quick and easy to obtain, especially if you provide someone with a privacy notice or privacy policy and you have consent at the bottom. It's good to capture that and hold on to it for dear life. Contract, performance of a contract is another easy thing to do, because if someone asks you to do something and they submit a PO or something like that, that is basically going to be your ticket to processing their data. You can't perform this PO without the certain data. You need it to do this. That is your lawful basis to process the information. Legal obligation could be performance of a different contract, could be just complying with any applicable EU member state law. The GDPR is defers greatly to individual state law within the European Union, European Economic Area, which is the EU, some of the Nordic countries, and Switzerland. Well, for purposes of the GDPR, Switzerland's included, even though it's not actually in the EEA. And then vital interests, protecting someone's life, public task, would also subsume some public interests like public health, things of that nature. Legitimate interests, some people try to invoke. It's a tricky wicket. There's a specific analysis you have to go through, weighing pros and cons of what you're doing against how it looks against the rights of the individual. You can't do something that grossly outweighs the rights of the individual or their interests. but there's a three-part process to go through the analysis on legitimate interests.
So an interesting side note. So how many of you received a privacy notice update notification when GDPR came out? I'm sure
You all did.
mostly everybody. So a lot of times those notifications were not required because they could have relied upon either legal obligation, contract, or even legitimate interest in some points. So it just seemed like the herd, everyone was following each other. So, a few people sent out, Google or Facebook sent out a privacy notice update, and then everybody else a few days later sent it out. And it's pretty interesting.
You wanted to be on that end of the bell curve so that nobody was looking at you on the other end to bring one of the really massive fines or enforcement actions. So yeah, it was better to be a little bit ahead of the curve than a little bit behind. All right, consent, it's pretty simple. I think we all have a general understanding of what consent is. It is a clear, unambiguous, readily understandable affirmation that you agree for something to be done. It should not be bundled with any other consent. It should be individualized consent according to the GDPR and different case law that's come out and white papers from the Article 29 Working Party. Most recently, out of Germany, there was a case called Planet 49, where they pre-checked consent boxes for cookies and marketing emails, and this was deemed to not be valid consent because you had pre-checked it for them as opposed to letting them check and affirmatively opt in, essentially, to receiving these cookies and marketing emails. Everything must be freely given, and like I said, must be an opt-in. So, next. The rights of individuals, and if you want to go back and forth on this, happy to do so. So the first two really relate to each other quite a bit. It all stems back to the transparency principle. Right to be informed is, well, we'll just jump into it, but just comprehensive disclosure requirements. If you updated your privacy policy and you feed this to all of your users before collecting their data and processing their data, chances are you probably satisfied this already. Now they can also request more information down the line, but this is a good starting point and it gives them a good understanding of what you're doing with their information. It will probably lay out where they're getting the information, the purposes, the legal bases, and it'll also spell out the rest of their rights to have a pretty GDPR compliant privacy policy. If you're engaging in automated decision making, and I don't think many people do outside of the insurance industry, but this might be a loaded question in this room, you have to make certain additional disclosures and perform a few extra steps on your side, including allowing for human intervention. Then we have the rights of access rectification and deletion. Like I said, you have to spell out everyone's rights within the privacy policy. You don't have to go into tremendous detail, but a good paragraph saying, you have X, Y, and Z rights under the GDPR.
Sure. Right to rectification. So pretty much going back to before, you must have accurate records of any individual. So any personal information you hold has to be accurate. So whether that be obtained by going back to the individual and confirming that, or some other way, you must establish that it's accurate. It kind of pretty much all of these rights go back to the principles, as you'll notice.
And if any of you are into the hard contracting aspect of the GDPR, you'll probably see, especially on the controller processor agreement side, that everyone's trying to flow these obligations down. So controllers flow these down to processors saying, you will make sure you send us everything that's accurate, everything you send us is accurate. And they will turn around and say, you're gonna make sure everything you send us is accurate before we process it. And then we'll say everything we give you is accurate. So it's baked in there, and it's pretty, at least in my practice, pretty heavily negotiated. Nobody wants to represent or warrant anything's accurate. The right to be forgotten, also known as the right to be deleted or have your information deleted. Erasure is one of the required rights, but it's not an absolute. There's certain instances where a controller or processor will not have to delete your information, especially if they have to keep it in order to maintain compliance with certain legal obligations. A lot of the European countries have certain data maintenance laws in place. France and Germany require you to maintain certain criminal records for, I forget what it is now, it's been a while since I've looked at it, 3-5 years. But there's other examples to this effect, and just general, I guess, accounting purposes as well are usually excused in legal obligations as well.
HR is the big one. Every company has a certain obligation to hold records for a certain amount of time, and those can't be deleted. So really, it's just following your record retention policy if you have one, and making sure that you don't, in line with the right to be forgotten, you don't delete information that you're legally obligated to hold.
Also true, also true. So in that same vein, data should be deleted almost automatically when it's no longer needed for the actual processing purpose, or if the data subject revokes their consent. However, you can overcome the revocation of consent in certain instances. So again, you're still not required to necessarily comply with that request, but you should at least tell them that you can't or you won't, and give a reason why, so they can be informed. And then objection, which is kind of similar. It's a next best alternative if you can't offer them, if they can't collect on their right to delete the information. So they would basically object to you processing it for any other purpose but the one you're obligated to, the reason you're obligated to maintain the data, like complying with an applicable law. Again, restrict processing is a next best alternative in the event that you have data that could be deleted but shouldn't necessarily be deleted, but there was unlawful processing, or if you have to maintain it but it can't be deleted. So these are all just next best alternatives. You want to take portability?
Sure. So data portability is really just providing it if somebody asks for an access request comes in and somebody asks for their personal information, a copy of their personal information, you should provide it in a readable format, such as a Excel format, PDF, JSON, or whatever that, JSON maybe not, but Excel, CSV, some format where a regular individual could understand, or transfer that data to another institution. So, for instance, open banking law, which is another European law or UK law, requires banks and other institutions the ability to transfer that data over to another bank. And Europe is really stressing that. So portability is part of that, where you have to provide in a format that allows you easily to transfer it over to a comparable service. So you'll see Facebook, Google, other media or ad tech companies providing you the ability to transfer it out. To what other service, I don't know, but
yeah,
that's
what's the alternative to Facebook, exactly. Honestly? I can't think of another controller. So there's a few important exceptions here. One, this will only apply to the extent that you provide the information to the controller. If they acquire it from other sources, it's not going to be swept up into the data portability, right? And also, it's only going to be based on information that is processed according to consent or performance of a contract. So there's a few limitations that you can dance around if you're trying to avoid necessarily providing or complying with this request. Right to object, again, some of these are all very similar. It's almost getting redundant saying it now, but basically it gives you the right to preclude processing under a few certain circumstances, but it's not absolute. Most often it's for marketing purposes. You will object to having your data processed for marketing, indirect or direct, I believe, actually. But and there's exceptions to that too. I mean, if you need it for a public interest, such as public health, if it's a particular piece of health data that is letting them know that there's a plague coming, they're not going to have to comply with your right to your objection to processing because it's in the public interest. It serves a greater purpose. If it's to comply with an official authority, the government under the GDPR of whatever member state has a lot of leeway here. The GDPR, in fact, doesn't apply to them directly. They have certain exceptions like they have here. But I'm not sure really what their obligations are in terms of protecting the data. I know here there's FOIA requests, but in Europe I'm not sure if there's an equivalent. So once something goes to one of the various government agencies in Europe, I don't know how much protection they actually offer. Do you?
I do not.
Oh, okay. It's an interesting concept though, because I always wondered about that here too. I never thought about it in Europe. Again, we see the other exception is legitimate interest, but again, if you're not ready to go through that process of evaluating the data in the three-step process against the rights of the individual, I wouldn't necessarily rely on this. The good thing about legitimate interest, if you do go through and prove everything, that you have a legitimate business interest, you don't have to worry about anyone revoking consent. You can still process. So that's one upside to the legitimate interest. Okay, so we talked about this briefly, and it doesn't come up very often, at least in my practice. But again, I believe the insurance industry is a ripe industry to discuss this for. Automatic decision making is essentially categorizing, profiling people, and lumping them into one group for a certain benefit or a certain tier of product. Analyzing different pieces of PII on someone and saying, oh, well, they're only entitled to so much insurance, or they have to pay a certain premium for us to talk to them and give them any policy versus someone else who might have different criteria, different personal information. They receive the same product, but they pay a different rate. So that's the best, most common example I can think of.
You could also make the argument in credit limits as well with credit cards. I don't know if everyone's seen the Goldman Sachs Apple news event that came out the other day, where one individual, a wife, got much lower credit limit than their husband, and so even though that's not GDPR related because they're in the United States, it's just an interesting example of where whether that is a privacy or civil rights issue. Because it had to do with gender discrimination, but also from a U.S. perspective, because we haven't dealt with the more data use ethical side, as we kind of just spoke about before, until recently.
All right, moving on to the accountability principle. This is where we're really going to pick up some steam in terms of enforcement. I'm not sure if anyone in here is a nerd like I am and actually tracks all the enforcement actions going on. If you focus mostly on the US, probably not, but we'll get to that. We'll cross that bridge when we come to it. All right, so we talked about data privacy policies and various other policies put in place to protect your data. This could be data handling procedures. This could be policies on how you respond to data subject requests, who has access to what, and then some more physical security and breach response policies as well. Data protection by design or by default, depending on what side of the coin you land on. Various contracts, which bulk of my practice. Documentation, security measures, and the ever popular DPOs, data protection officers. So, skipping ahead from policies because that'll vary person to person, we're going to talk about contracts. The GDPR literally requires you, if you're a controller, to have in place with anyone else you transfer data to, outside of maybe your immediate corporate structure, a contract under Article 28, and it sets forth 11, 12 criteria that must appear there, but some people will try to pepper in certain business terms, indemnification, limitation of liability. I represent mostly small and starting venture companies, like startup companies. They don't have a huge budget for negotiation and really hammering these things out. So if they have a sales agreement or commercial agreement in place already, I will limit the terms in my data protection addendum, which is the contract, most people usually call this contract, to just those base terms. And I will put exactly what is required in there to help them get over that threshold, because they just need to be able to say they're compliant, whether they're a controller or a processor. So it's a matter of how deep you want to get into it. If you really want to throw your weight around, you push for those other legal areas like indemnification, but it's not actually spelled out under the GDPR, nor is who pays for what. The GDPR is notoriously silent on who's going to bear what fees, so that is usually something that pops up anyway in my negotiations, whether it's cooperation or who's going to pay for the audits. So try to shift as many of those fees to the other party as you possibly can. Another, unlike the CCPA, and I'll get into this later, and again, this is my personal opinion, not that of McCarter English or any of my clients. The GDPR was very, very smart in their ambiguities, whereas the CCPA did it just to get things across the finish line in the matter of a few days. The GDPR says you have to have appropriate technical and organizational safeguards to protect the data, the confidentiality, the integrity. That was by design. They understand that not everyone has Google's budget to protect data. Not everyone has McCarter English's budget. Not everyone has, the startup down the street's budget. You need to be able to show you're doing the best you possibly can, and preferably show that you're treating more sensitive data more securely than less sensitive data. But that's the long and short of it. It's do your best possible job at protecting this data. There's no guidepost I can give you. It's do your best and show that. If you improve something, great, do better. But if you can't do as good as Google does in protecting data, they're not going to hold it against you. In fact, Google doesn't do that great of a job anyway. So says the CNIL out of France, $50 million fund. All you.
Data protection by design default. So this is an interesting one. Actually not a European concept, believe it or not. Originally referred to as privacy by design, which was coined by Dr. Anne Kavoukian. Pardon my Canadian French, not so good, but she was the Ontario Information and Privacy Commissioner, former, and she coined the term, which essentially just means baking privacy into all your business processes. So from the beginning, when you collect the data, towards the end, when you destroy it or whatever with it. And so essentially, it's a pretty difficult, it's a simple concept, but pretty difficult to implement in reality. And I think a lot of engineers and a lot of people in general have difficulty, ensuring that they're in line with privacy by design. But interesting enough, GDPR kind of stole, the term, changing it to data protection by design default. Next slide, sorry. So data protection by design, which is kind of pretty much what we said before. An example of this, actually, my favorite example, is the iPhone itself. So, so when you use Face ID or Touch ID on your phone, your fingerprint or biometric data is secured by a separate processor on your phone. It's not stored with the rest of your personal information. Interestingly enough, if you use a Face ID or Touch, depending upon what model you have, the information is never sent to a third-party developer or iCloud. It is stored on your phone. The only thing a third-party developer, such as a bank, if you're using your banking app and you want to log in, you want to just conveniently use your Face ID, the only information that they'll receive is that you are authenticated. They'll just receive a tiny API request that you are authenticated. So clearly Apple really thought through the privacy and data protection concerns when they were developing these products, and a number of other products that they develop as well, but I won't bore you.
Hence their recent commercial advertising campaign. I, for clarification, don't use face unlock or fingerprints or anything like that because I'm neurotic. But all right.
And then the other half of what GDPR called data protection by default is just having a privacy first approach in your default settings. So, for instance, LinkedIn, if you had a social media, any sort of social media application, when you sign up, it should be on a privacy default setting. So your information, your personal information, should not be shared with everybody unless you turn your settings to public. So it shouldn't display that XYZ visited your profile, for instance, with LinkedIn, until you change it to that settings. That's kind of what privacy by default means. Whether the difficulty of doing that is debatable, but it was on the previous slide. There's a number of kind of concept that the private industry is coming up with. Deloitte has a certification now. ISO, there's an ISO, I believe it's in progress, or a draft was released pretty recently on consumer privacy by design. And then the OASIS, OASIS or OASIS, it just looks like OASIS, privacy by design documentation for engineers. That has been released for a few years now and is going through. So there are a few kind of guides on how to implement privacy by design. So, it's not just a one sentence thing, so yeah.
Onward transfers, and this is all got a giant asterisk next to it. I'm not sure how many of you are familiar with. There's a case pending right now at the Court of Justice of the European Union that actually got delayed till I believe next week. So the principle of onward transfer is that you have received personal information from somebody, in order to complete your processing, you need someone else to fill in, and you have to transmit this data to them more often than not across the border from where you are, whether it's US to Canada or EU to China or where have you. It has to go outside of the European Economic Area or one of the areas that they have designated having adequate privacy policy or privacy in place, privacy standards in place. So some of the more common examples are the standard contractual clauses and the privacy shield framework. Binding corporate rules are, I would say, a distant third, because you have to go through a certification process, which is actually a real certification process, not like Privacy Shield certification process where you simply submit your documentation and you're done. By far the most popular are the standard contractual clauses, and you'll usually see these at the back of the data processing addendum I talked about earlier. This changes what should be 4-page document into a 20-page document, because you cannot change these. This is a document, this is a huge contract offered by the European Commission that you don't change. You just write in everyone's names and that's it. If you change anything in there, you basically open it up to challenge and invalidation. So you don't want to change anything there. But it's simple, you don't have to think about it, you sign it, you forget it, and you put it away until Max Schrems comes into play. So, like I said, Privacy Shield and the standard contractual clauses are by far the most popular. Privacy Shield just entails sending several documents to, for the U.S. Department of Commerce, or I don't know who would be in for Switzerland, but DPA, the Swiss DPA. And it's just a framework you abide by. And you say, I'm going to do X, Y, and Z, and you recertify every year. In the same vein, the European Commission examines the Privacy Shield every year to determine if it is indeed providing adequate protection for transfers. They did it in October for the third time in a row. They deemed it to be adequate, but we'll see how this plays out. Like I said, there is a court case pending in the Court of Justice of the European Union. Max Schrems is an Irish national who actually several years ago, or not several, but a handful of years ago, invalidated what's the word I'm looking for? The Safe Harbor. Thank you. Sorry. Safe Harbor, which was the previous mechanism in place. And he said, I don't think this is really adequate, so I'm going to bring a case and I'm going to invalidate this. And sure enough, he did. So when GDPR went into effect, Privacy Shield followed suit. He's trying to do the same thing again. He's trying to invalidate both the standard contractual clauses and the Privacy Shield, which is going to create the biggest mess for everyone if he succeeds. And that decision should be coming down in a matter of days. So by the time everyone might be comfortable with where their CCPA stands for January 1, they might have to start worrying about getting a new Article 46 mechanism in place for onward transfer. and that is not going to be a small endeavor. Okay. Back here is it's a lot of background information. Privacy Shield, like we said, is a self-certifying framework that covers transfers to the US and Switzerland from the European Union, or economic area rather. And it's, like I said, it's a very simple thing, but you have to do it every year, whereas contractual clauses, you do it once and you're pretty much set, unless they're invalidated. Usually in the Article 28 data processing addendum I talked about earlier, there's some language to the effect of, we will have an onward transfer mechanism in place, and if it's invalidated, because everyone's always afraid there's invalidation coming, we'll work promptly to put something else in place. So, fines and penalties. Fun, fun, fun. So there are a lesser tier of fines, 10 million euros or 2% of your global revenue, but most people focus on the upper end of that echelon. With good reason, it's a bigger number, it's scarier. I don't know if there's actual justification for feeling that way, though. I think there's been roughly 100 or 110 enforcement actions since the GDPR went live. And yes, there's been quite a few larger, big ticket, highly publicized cases like Marriott, like British Airways, like Google. Actually, yesterday there was one out of Germany that was 10 million euros roughly.
Yeah.
But some of those are 50 million euros, 100 million euros. But these, again, are much bigger companies, and they did not necessarily implement appropriate technical safeguards. That's usually what the big ticket fines come for. Now, there's also quite a few stemming from not complying with principles, not having a legal basis to process data, but the fines are coming and they're picking up steam. The last half of 2018, there wasn't much going on, and there's been at least a tenfold increase in cases since then. And you'd think there'd be more, though, because of how much processing goes on and how many entities there are out there. But most of the data privacy authorities, which is the government organization in each country or region, for Germany, for instance, are slow rolling this. They want to make sure they do everything right, set a very good precedent, and build a very strong substantive case that's going to essentially pay them the fine. The other aspect of this is many of them are underfunded. They're going to be relying on the fines they bring in, and they don't have the staff to bring to many of these enforcement actions. So as more fines come in, the number is going to increase exponentially as they get more headcount. All right, we touched on this before. Controllers and processors can be liable under the GDPR. If for some reason the processor the data subject, the individual, can't find the controller, they can go straight to the processor, vice versa. So most of thank you. Go ahead.
The liabilities, those are fines payable to the government, or are these private rights of action?
There is a private right of action, but the fines are directly to the governments.
But a lot of times, just like in the US, if there's a fine, there's going to be private right of action.
Smoke and fire situation. But it's, one might trigger the other or vice versa. But like I said, these two entities are both liable. They can fight it out in court, their particular percentages later on, and squabble over indemnification, their percent liability. That's their business. But for the purposes of violations, it's one and done. More of the fines I talked about. So British Airways and Marriott International are the high-ranking ones right now. The Information Commissioner's Office is the DPA in Great Britain, and they are really making their mark. They don't bring many cases, but they bring the high-dollar cases. And both of these companies were fined because of Article 32 violation. So again, make sure you do as much as you can, and you reasonably can as an organization to protect the data, technically and organizationally. France, Google Google got fined for everything under the sun except for Article 32. France, I guess, just didn't really like the cut of their jib and hit them with 50 million euros. I'm actually kind of surprised that there aren't more Google fines flying around the European Union, or Facebook for that matter, but the year is, 2020 is still in front of us. More is coming. Just a few more fines. Austria, there was a enforcement action against the Austrian mail company, the post office, essentially saying that they were holding information far longer than they should have. And then the next largest fine came out of Germany for a real estate company, again, holding people's information a little bit too long without a proper removal mechanism. So you see that there's a huge drop off from 200 million, 110 million, 50 million, and now we're below 20 million. So
I think just something to add there. I think the big one to watch is Ireland, though, because most of the tech companies, or what we consider tech companies, have their main DPA, Data Protection Authority, in Ireland. They're registered in Ireland. So we'll see what the Irish Information Commissioner, she said, she's going to have something for us early next year. So we'll see.
She waited for Trump's to.
Yeah.
All right, so that's all she wrote. Everyone, here's some of our materials. You'll see them in the back of your packets. If you have any questions, I think we're good on time. Nothing. Oh, yes, sir.
So what happens with Brexit?
I didn't want to drag that into it, but
it's a mess.
It's a hot mess. It really is. It depends if there's a deal, if there's no deal. If there's no deal, what are they going to put in place? I'm told they're going to do a UK-style GDPR analog to go with their 2018 Privacy Act, but it's going to strongly favor the UK companies. It's going to require an additional onward transfer mechanism going into the UK from the rest of Europe, but everyone in the UK will be hunky-dory. They already have theirs in place. So it's going to add a few headaches to certain people.
And then, just like every other, company in terms of every other area of the law, you want to think about if you're a company that's registered with the ICO in the UK, you have to think about registering with another data protection authority, so have a backup plan in case Brexit does occur.
Talk about so data subjects benefit from this protection here, but who are they? They're not U.S. persons. I mean, how do U.S. companies think about that?
That's a good question, and it goes back to how does the GDPR apply? The GDPR will apply when there's processing of personal information of European EEA residents. Now, if you have a home base if your company has a home base in Europe, it will apply to you immediately. If you're a non-European company and you're processing information of European individuals, even if you're not based there, it can still apply to you. If you're continuously monitoring people in Europe and you're based outside of Europe, it'll apply to you. And what's the last one? The last one is if you're marketing goods or services to the EU, it'll also apply directly to you. However, it doesn't really matter because someone in your supply chain is subject to GDPR and they're going to make it flow down to you. So it's really everyone's problem.
So, for instance, if you're traveling in Europe, it's going to apply to you. So I was traveling right after GDPR was implemented. I was in.
Well, when you say you're talking about me as a data specialist.
You as a data.
Or I'm talking. I mean, so there, you can be, like a company, U.S. company.
It's people only, not company, not corporate information. So your name, your address.
But U.S. companies, non-EU or EEA companies need to be aware of whether or not the people interacting with them or whose data they're collecting are data subjects or not.
Yes.
Right.
Yeah. One of the privacy terms that flies around my office quite a bit is data mapping. You need to really have a good inventory of your data, where it came from, where it's going, things, just to help you comply. Some people choose to treat everyone as if the GDPR applies to them just for one less headache.
Which is why you saw those emails.
Exactly right, yeah.
And some people don't. They want to minimize their obligations. but that's company to company. So
I've noticed that a lot of access requests in Europe come from employees. How should we treat employee rights for GDPR purposes?
That's an interesting question. Well, I mean, you technically have a very ongoing business need for some of that information. Not all of it, but if they're a continued employee over the course of many years, you still need some of that information.
Yeah, sorry. So it really depends on if it's a request to access or delete. So if it's a deletion request, you have an obligation to hold on to it. If it's an access request, I mean, you know, we should be providing that information, or at least a lot of it. So it's going to be subject. GDPR is not. The thing with GDPR, it's not like CCPA. It's very context neutral, technology neutral, and tries to be ambiguous or broader on purpose. And CCPA, you'll see it gets way more specific. Unfortunately.
I think we have one more.
Yeah, one more. Okay.
Yes.
You talked about pass-through obligations earlier. Are you finding in your practice it's getting harder to negotiate with service providers to take on more obligations, especially technology service providers that use cloud? And do you have any practice points for that or practices?
I find that it's I think situation dependent. It depends on how badly the smaller company, the tech startup wants to do business with the big name. Are they doing this to be able to say, hey, look, I'm working with Google? The question was, how do you find in practice smaller tech companies, are they willing to take on certain GDPR obligations for the larger companies that might be directly subject to the GDPR? And I think it's very situation dependent. It depends on the desire to work with them, how much it aligns with what they already do, if it involves a huge financial burden up front, and just how basic I would say the terms are. Because if it's just straight GDPR compliance, I've been trying to guide my clients in that direction anyway, because I sense it's going to pop up in other countries too. I mean, it's already going live in Brazil February 15th, and they're not going to be the last country that has their own GDPR copycat. So I really strongly advise clients to get behind these very broadly applicable principles already, and it'll open more opportunities for them down the road.
I think it's also interesting as a service provider. I mean, the same issues are rising with CCPA. So it's your bargaining position, right? So at the end of the day, it potentially could be a business decision, all right? It's your business, how much risk they want to take on, and it's just advising them in the proper way.
All right, I would like to thank both of our co-presenters. Round of applause. And I would like to call up the practice chair, Joe Daniels, for the technology and the VC practice here at McCarter in English. Joe has been very helpful and instrumental to us, and without him, we wouldn't have had the space today. And many of you know, getting space in Midtown in a great location like this is very difficult. So Joe has been very supportive of InsurTech New York as an organization, so we're really glad to have him, and he's going to share a few words about his practice.
Thank you, David. How's everybody doing today? Good afternoon.
Good afternoon.
How many startup entrepreneurs do we have in the audience? Oh, you're all in the back. How many is that, 3 or 4? And how many lawyers do we have in the audience? Okay, my kind of people, right? So, then if you would just maximize that. So I merely put the title up here and my name, Joe Daniels. I'm a partner and co-chair of the Venture Capital and Emerging Companies practice in McCarter in English. I just wanted to tell you a few things about our firm, since you're in the office. We're 175 years old, a full service firm. So we must have been doing something right for a while. And we have everything that a business needs, like every other big law firm, right? Real estate, tax, litigation. I'm part of the corp, and we have 400 lawyers and 9 offices throughout North America. I'm the co-chair of what I think is highly ranked the venture capital and emerging companies practice. And what we do is we help basically companies to form up, protecting their equity with vesting and protecting their IP with agreements and filings and raising angel and venture capital financing in successive rounds, and growing through acquisitions and commercial agreements and joint ventures and international expansion, and then exiting through mergers and acquisitions and IPOs, usually in the technology, life sciences, and consumer space. We're usually ranked in the top 3 to 6 firms regionally, 5 to 9 nationally and globally. Even though we just started assembling this group back in 2014, it's about 35, transactional lawyers, 50 including intellectual property. We represent about 1,500 startups and funds, including some of the more prolific VC investors in New York, like FFVC, at least at the early stage. And last year we did about 280 deals for about 4.4 billion. This year we're on track for 230 plus deals. Actually, that's 290 plus deals for about 5.6 billion. So that does reflect some growth in the venture economy, but also our growth. I also wanted you to know that we have a 120 lawyer IP group that basically does the patent, trademark, and copyright, prosecution, litigation, and licensing. We have some licensing attorneys, including Susan Goldsmith, who's speaking later today, and Morgan Jones, who was just up on stage, and over 100 litigators ready to sue and defend all over the U.S. And I have to talk about myself, right? I've been doing this for 23 years. After I graduated from law school, I joined the group that took Netscape public. Who's heard of Netscape? Oh, that's good. I can still say that for like 5 years, right? And here's some of the big companies I've represented. People in the back can't see. It's like Autodesk, Invitrogen, which is now part of Life Technologies, which is a multi-billion-dollar company, Monster Worldwide, Polycom, a bunch of venture funds, investment banks like Credit Suisse and Morgan Stanley on the underwriter side of IPOs. So I'm fairly familiar with the entire life cycle of tech and life sciences companies. Of course, we're happy to help out with your corporate and fundraising matters, not just the GDPR and California privacy stuff. So let me know. I'll be networking during lunch, and I'll leave my cards out on the desk here. Just ask the reception people if you want to talk. That's it.
All right. Thanks, Joe. Really appreciate it. So for the rest of the day, we're going to continue back in content, but for right now, you have about 45 minutes for lunch. So for those of you who haven't eaten, please grab something for lunch. And please, as I was mentioning, there's a really good mix of you guys in the group. So please network, and we're going to come back right around 1:30, and we'll hit the second part of the law, talking about CCPA. Thanks.